Hi, it's again stcherniak in Berlin Immobilien. On October 22nd, 2020, the new edition of the WEG Owners Association law has been approved by the German Parliament, Bundestag. This is a federal law and concerns all the territory of the Federal Republic of Germany, not only Berlin. There has been many discussions about this law in the media. Most of the commentators say that this law favors the managing companies. I do not agree. Let us understand why. And if you like what I do, give me likes and share this information. Don't hesitate to ask questions. I will put the full text of what I'm talking about in the description to this video. Let's start. This law is intended to facilitate the achievement of the climate targets set by the German government through energy renovation of the residential properties and creating the infrastructure for charging the electric vehicles. From now on, each owner of an apartment in Germany has right, without anyone's consent, to provide in his apartment the charging infrastructure for an electric car, barrier-free access to his apartment, to install protection of the apartment from burglary, and provide access to the high-speed internet from his apartment. Further, repair and modernization of the apartments by owners are now simplified. The planning and redevelopment of public spaces are legally simplified also. A simple majority is sufficient in voting for the repairs in the building. In the past, the whole 100% of the owners were needed for it. Nevertheless, if more than half, but less than 2/3 of the owners voted for the repair, the house will still be repaired, but only those of the owners who voted for it will pay for it. If more than 2/3 of the owners voted for the repair, then all 100% of the property owners would pay for the repair. Doesn't matter how you voted. The payment would be made in accordance with the owner's share in the total property, in this case. The individual owners have the right to be exempted from the participation in costs if these costs are unbearable for them. But the exact numbers of and the explanation of these circumstances and sums are not given in the new edition of the law. Repair costs may be forcibly charged to individual apartment owners if the repair costs offer a sufficient depreciation for a sufficient period of time. Nevertheless, the legislator does not explain neither what a sufficient period of time is, nor what amount are unbearable. However, depreciation period in the last edition of the law was ± 10 years. So we can suppose that also in this edition it's also ± 10 years. According to the previous version of the law, the management company was not required to have proof of its professional qualification. Now it is not required to have this proof either. But the law recommends the WEG, the Association of the Owners, to require this document, this certificate, from the managing company. The new law also defines what exactly this certification of the management company is and looks like. The certificate of the professional management company is issued by the German Chamber of Commerce, Industrie- und Handwerkskammer, after passing the exams that cover the legal, business, technical aspects of the real estate management in Germany. Real estate management companies receive 2 years from the date the law comes into force, December 1st, 2020, to pass the required exams and obtain the appropriate certification. Starting from December 1st, 2022 only, the property owners have the right to demand from the management company the appropriate certificates. Nevertheless, the management companies are not obliged from the point of view of the new law to be certified. It's only a recommendation. Certification and examination are rather recommended. Management companies that already have management contracts with the buildings receive a grace period of 3.5 years to obtain the appropriate certification, and for this period of time, by default, they are equal to certified companies that have passed the examination of the German Chamber of Commerce and Industry. An exception from the right to require the professional certificate from the management company is made only for the buildings with 9 apartments or less, and only if the building is being managed by one of the apartment owners himself in the building. However, if 1/3 of the apartment owners decided to order a certified manager, then a certified manager should be ordered. In 2018, another law came into force. It requires the managers to take a minimum of at least 20 hours of educational courses every 3 years. Not 20 hours a year, 20 hours in 3 years. This obligation remains in force under the new version of the law. The new edition of the law unambiguously defines that only the official council of the property owners has the right of expression of the will of the whole owners association, WEG. This removes the discrepancy that any gathering of individual apartment owners in the building could be considered the expressor of the will of the property owners. It means that if all the property owners come to a cafe or a park or restaurant and take a decision, this decision would not be valid. People should gather under the auspice of managing company, have protocol, and officially take decisions and protocol them. If the new edition of the law, in the new edition of the law, the management company can independently decide on its own responsibility about minor repairs in the house if they do not lead to significant financial obligations. The legislator, nevertheless, does not explain what exactly these significant financial obligations and what minor repairs are. The new edition of the law allows the council of the owners to determine the maximal money limits allowed for the managing company to transfer to any third-party suppliers, repairmen, or service providers. Without the specific consent of the council of the owners, and they determine a catalogue of activities that need no special consent of the council of the owners. The previous edition of the law gave the unlimited power of attorney to the management company. It might be used to obtain the bank loans and to sell the real estate on behalf of the property owners. The new edition of the law allows this nevertheless only with the special additional power of attorney. To make the long thing short, the managing company from now on, mostly for any new activity, needs a specific power of attorney from the council of the owners. In the new edition of the law, the property owners have right to participate in voting via the internet. There will no be need in personal presence at the voting. In the new edition of the law, the council of the owners has the right to make decisions on behalf of all the owners, regardless of the number of the present property owners on the voting. This should reduce the costs of the management company for repeated owners' council meetings. Further, property owners should be informed about the council meetings at least 3 weeks before the meetings take place. as opposed to 2 weeks in the old edition of the law. The management company gains the right to invite owners to the meeting by email. Previously, a hard copy of the letter had to be issued and sent by post. Now the protocols of the council owners meetings must be in text and not in hard copywriting. It means the managing company needs now to send the hard copy letters via post with the protocols. Rather, they get the right to send the protocols by email, in messengers, via websites, and so on. Each property owner in the building received the right to check the managing documents of the management company without any specific reason. No decision on the account of the cost distribution now requires a qualified majority. Simple majority is sufficient. The property owners in the new edition of the law can fire the managing company at any point of the time and need not to have any sufficient reason to do so. A dismissing notice of the managing company must be sent to it at least 6 months before the effective date of this dismissal. The decision of the council of the owners changing any agreements between the owners and the managing company now requires the mentioning in the Grundbuch, land registry. This is intended to protect the future buyers of the apartments in the building. From now on, the owner of the apartment receives the right to vote in the council of the owners from the moment the apartment is handed over to him and not from the moment of registration in the Grundbuch, land registry. Thus, there is no need to wait for the final ownership record in Grundbuch, land registry. And thus, the very concept of future owner of the property is being eliminated. Important decisions of the Owners' Council are now void until they are submitted to Grundbuch. But the legislature does not define what the important decisions are. In the new decision of the law, the concept of the special right of usage, Sondereigentumsrecht, is equated with the concept of the special property, Sondereigentum. This avoids simple confusion. In the final annual financial statements, the management company is now required to indicate the total savings amount of the future repairs, which was not necessary before. And the last not least, under the new law, the tenant is obliged to obey the owner's decision to renovate the apartment. If you like what I do, please give me likes and share this news. Don't hesitate to ask a question. Stcherniak, Berlin Immobilien. Bye.